Is spousal consent needed for retirement account beneficiary changes? Have you ever wondered if you need your spouse's approval to change the beneficiary on your retirement account? This is a common question that many people have when it comes to estate planning. The answer can vary based on the type of retirement account you have and the laws in your state. Let's break it down. For retirement plans governed by the Employee Retirement Income Security Act, such as a 401(k) or 403(b), spousal consent is generally required if you want to name someone other than your spouse as the primary beneficiary. This law is designed to protect the rights of the spouse to receive survivor benefits. If you decide to make a change, your spouse will typically need to provide written consent, and this may need to be notarized. If you do not obtain this consent, the plan may automatically name your spouse as the beneficiary. Now, when it comes to individual retirement accounts, or IRAs, the rules are a bit different. IRAs are not subject to the same federal regulations as employer-sponsored plans. In many states, spousal consent may still be required if you wish to change the beneficiary designation and your spouse is not named. This can depend on specific state laws, especially if your state has community property or elective share laws that protect a spouse's interest in retirement accounts. Therefore, it is wise to consult local laws or speak with an estate planning attorney to understand what applies to your situation. Understanding why spousal consent is important can help clarify its necessity. It ensures that the surviving spouse is aware of any changes that could affect their financial security. Retirement accounts often bypass probate, meaning they go directly to the named beneficiaries. If a spouse is not included and no consent is given, they could be left out entirely. When planning your estate, consider reviewing beneficiary designations regularly, especially after significant life events like marriage, divorce, or the death of a loved one. It is essential to keep these designations consistent with your overall estate planning goals. Remember, beneficiary designations on retirement accounts typically override any provisions in wills or trusts. This means that, if you want your retirement account to align with your wishes, you need to ensure it is updated accordingly. Properly managing beneficiary designations can also help avoid probate. This simplifies the transfer process and may reduce legal costs, making it easier for your loved ones during a difficult time. In summary, for retirement plans governed by federal law, spousal consent is usually needed to change the beneficiary away from a spouse. For IRAs, the requirements can vary based on state law. Always consult with an estate planning attorney to ensure that your beneficiary designations reflected your wishes and comply with legal requirements.